Hello everyone, welcome back to my channel Study with Neha Mawa, and I'm back with another video. In this video we are going a step further in our contempt of the Court Act 1971. In my earlier video we have completed from section 1 to section 6 till complaint against the presiding officer of subordinate court when not contempt. So in today's video I'm going to start from section 7 till section 13 when the contempt is not punishable in certain cases. So without wasting time, let's get started. But before that, please subscribe to my channel, like my video and share with your friends. Let's get started. So today we have to start with section number 7 of your Contempt of Court Act 1971. Now what section 7 tells about? Section 7 says that publication of information relating to proceedings in chamber or in camera not contempt in except in certain cases. Now section 7 says that when you are publicating any information, when you are publicly releasing any information that is related to the proceedings in chamber, right, whatever the proceedings are there in the court, in the chamber, when you are publicating those information to general public or in camera, is not contempt if the information or if the relevant information is true to its full capacity. There are, but they have given you the exceptions here, right? Except in certain cases. First, notwithstanding anything contained in this, a person shall not be guilty of contempt of court for publishing a fair and accurate report of judicial proceeding before any court sitting in chamber or in camera, except the following cases. So before this, let me tell you, says that if you are publicating or if you are publishing any information that is true to its knowledge, that is as real as it was in reality, that that is being published in a good faith with the with the good or with the real content or information contained therein, so here you are not be liable for the contempt of court because you are not publishing a false statement. You are publishing an accurate statement and accurate information that tend or needs to be published in order to make the general public to know that what is happening in the court, right? So if you are publishing some kind of information that is that is not accurate to its knowledge, means the reality is something different and whatever you are publishing is something different, there's a huge difference between these two, then you might get punished for the contempt of court. But for now situation if the information is real to its knowledge, that relates to the the information in reality, there is no contempt of court. But they have given you the certain cases where if you will publish those kind of information, that becomes the contempt of court. First, they have given you where the publication is contrary to the provision of an enactment for the time being in force, where the court on the ground of public policy or any power vested expressly prohibits publish of any information relating to proceeding. Means when the law says that you are not allowed to publish this kind of information that may hinder the the secrecy, that may violate some laws relating to secrecy, or that may violate the laws related to privacy of the country, still you are doing that, you will be liable for the contempt of court. But when the court says that strictly prohibit is these kind of information to be published, still you are doing that, then you will be punished for the contempt. Third is where the court sits in chamber or in camera for the reason connected with the public order or security of the state. For example, in the court, many high profile cases may come. For example, the case related to the country, case related to some kind of cyber security, some kind of secret information that needs not to be published. But if the person tries to do so, he will be punished for the contempt of court. And the last is where the information relates to a secret process, discovery, or which is an issue of the proceedings. When you are publishing some kind of information that may hinder the discovery of the country, invention of something, growth of the country, then you will be liable for it. Then, without prejudice to the provision contained in subsection 1, a person shall not be guilty of contempt of court for publishing the text or a fair and accurate summary of a whole or any part of an order made by a court sitting in chamber on in camera. See, it's a very simple procedure. It's a very simple case. If something is strictly prohibited by law, that you can't publish these information, and if you are not publishing those information, that is okay, because you are not violating the laws of the court or the country. But if you are violating those laws, still you are doing that contempt, means you are liable for it. You will be punished for the contempt of court. Then we have section 8. Section 8 says that other defenses not affected. It says that nothing contained in this act shall be construed as implying that any other defense which would have been a valid defense in any proceeding for contempt of court has ceased to be available merely by reasons of provision of the act. Means you are publishing something, you are publishing any kind of information that is against the law, that is strictly prohibited by law, so you can't expect that you will get the defenses against that if the information is real, right? For example, we are inventing some kind of a big project. We are focusing towards a big project that is very secret in nature. You are publishing the real information of that, but that information need not to be published because it's a secret invention that needs to be done. So you won't get any kind of defenses for it. Then we have section number 9, that is act not to imply enlargement of the scope of contempt. It says that nothing contained in this act shall be construed as implying that any disobedience. Now please look about these words: disobedience, breach, publication or other act is punishable as contempt of court which would not be published which would not be punishable apart from the act. It says that act not imply enlargement of the scope of contempt. That says nothing contained in this act shall be construed as implying that any disobedience, breach, publication by any person or any other act is punishable as contempt of court which would not be punishable apart from the act. Means when the person has done disobedience, breach of trust or publication of the information that was not intended to do so, that was not supposed to do so, you have to punish that person within the provisions of the contempt of court act, not out of that, not beyond that act. Then we have section 10, that says that power of high court to punish contempt of the subordinate court. Now please listen to this very 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 carefully and see this very carefully. Just a minute. That only high court and Supreme Court has given the powers to punish the person for Contempt of Court Act 1971. Right? Here they are saying that only High Court and Supreme Court, High Court and Supreme Court has power to punish a person for the Contempt of Court 1971. No other subordinate court has power to do so. So they says that if the contempt of court is done in the subordinate court against that, then who has the power to punish for that contempt? High Court. So every high court shall have and exercise the same jurisdiction, powers and authority in accordance with the same procedure and practice in respect of contempt of court subordinate to it as it has an exercise in respect of the contempt of itself. Means the high court has to take same steps to punish for the contempt of subordinate court as the contempt is done against the high court itself, right? Then, provided that no high court shall take cognizance of a contempt alleged to have committed in respect of subordinate to it where such contempt is offence punishable under IPC. Then we have section 11. Now here, as I told you that, let's say there is a contempt against the district court, right? District court, and district court is the subordinate court. Is that clear? Subordinate court. Then high court has the power to punish, right? Because district court itself can't punish the person for contempt of court, but the high court will punish the person, right? Or either the Supreme Court, whatever the case may be. Then we have section 11 that says power of high court to try offence committed or offender found outside the jurisdiction. See, a high court shall have the jurisdiction to inquire into or try a contempt of itself or any court subordinate to it whether the contempt is alleged to have been committed within or outside the local limit of its jurisdiction. Whether the person alleged to be guilty of contempt is within or outside such limit. So firstly we have to see that whether the high court has that much of power or authority to interfere in these matters. Yes, High Court has given the powers to interfere in the matters of the lower subordinate court whenever required in case of the Contempt of Court Act. As there was in the Contempt of Court Act, the subordinate court like district court, civil court, small causes court, they don't have that right to punish a person for the contempt of court. So who do the act? Who will do the act? Of course, the High Court itself. So it says that a high court shall have the jurisdiction to inquire. A high court should have the power to inquire into the matter relating to the contempt of court or of itself or any of the court subordinate to it. Okay. So the high court must have the jurisdiction to punish the offenders for that, whether it has been committed outside the local limits of the jurisdiction or inside the local limits of the jurisdiction. Now we have section 12 that talks about the punishment for the contempt of the court. So what does it mean? Section 12 says that punishment. It's a very important section because in your exam they might ask you that which section tells about the punishment for contempt of court. That is section 12 of Contempt of Court 1971. This will be the answer. Whether it's very important for your prelims as well as your mains also. Then we have punishment for the contempt of the court. See, save as otherwise expressly provided in this act or in any other law, a contempt of court may be punished simple imprisonment for a term which may extend to 6 months or a fine which may extend to 2000 or both. Now see, what kind of punishment they have given? They have given you either imprisonment, either fine, or sometimes both, as the case may be. So here they are saying that if a person is charged with the imprisonment. So the minimum can be anything. The minimum can be 15 days, 1 month, 2 month, 3 month, whatsoever it is. Depends upon case to case. And it may extend to 6 months. That 6 month is the maximum limit for the imprisonment. You can't give more than that. But as I told you always, as I said you always, that as I said that it depends upon case to case. And when we are talking about the fine, fine may vary again upon case to case, but the maximum limit of a fine is the 2000 rupees, and sometimes the fine or the imprisonment both can be applied. Then, provided that accused may be discharged or the punishment awarded may be remitted on apology being made to satisfaction of the court. If the case is not that much of serious nature, or if the case is that like that may get resolved with a mere apology, then the person you know the person be given or the person be discharged from the punishment when the person goes with the apology, and that apology must be done in a good faith with the full satisfaction of the court, right? Then an apology shall not be rejected merely on the ground that it is a qualified condition if the accused makes it bona fide, right? Then, second is, notwithstanding anything contained in the law for time being in force, no court shall impose a sentence in excess of the that specified in subsection 1, that is maximum limit of imprisonment 6 months, maximum punishment 2 months, not more than that. Third is, notwithstanding anything contained in this section, where a person is found guilty of a civil contempt of court, if it considered that a fine will not meet the ends of justice and a sentence of imprisonment is necessary, shall, instead of sentencing him to simple imprisonment, he may direct, or the court may direct the person to be detained in civil prison for a period not exceeding 6 months as the case may think fit. Getting my point? So they says that sometimes mere fine or mere apology is not enough for the person for the contempt of court. Because the person might have done some kind of contempt that is a very serious nature itself, that the imprisonment is very much necessary. Then we have subsection 4 of section 12 says that where a person found guilty of contempt of court in respect of any undertaking given to a court or is a company, every person who at the time of contempt was committed was in charge and was responsible to the company for conduct, then company can also be charged, or company will get also be charged for the contempt of court, right? It's not that always the person in general or the person in real will get the punishment for contempt of court. Sometimes the company may get also punished for the contempt of court, right? Then we have fifth subsection here, notwithstanding anything contained in this subsection 4, where the contempt of court referred therein has been committed by a company and is proved that contempt has been committed with the consent or convenience or attribute to any negligent on the part of director, manager, secretary, or other office of company, they will be liable and they will be guilty for the contempt of the court. See, if a person has done, whether the person is director, MD, secretary, whatsoever it is, when the person do their work carelessly, without awareness, neglect some kind of work that result into the contempt of court, then the person will be charged for it. Then no other defense will be available, because at that time when the contempt of court happened, they were not aware of the fact, they were not aware of the situation, means they were the careless, they were neglecting the main criteria or main important thing, right? Then they have given you the explanations here. Firstly, the company, as I told you, the body corporate include the firm, association of individual, and the director means the partner in a firm, right? So in general, what I'm trying to say is that contempt of court must not be taken lightly, because it might affect the person very badly, because the person is challenging the authority of the court, or challenges the administrative administrative of as it challenges the administrative of administration of justice, right? So if you are if for example the judgment is being delivered by the judgment, and you are making and you are saying the judgment is wrong, this judge is this judge is that, he don't know laws, he is like this and that, you are somewhere defaming, or you are lowering down the image of the higher authority, that is the judge. So you will be punished for the contempt of the court, right? So I think I should stop here till 12, and I hope you guys understood what I taught today. In my next video, I will be starting with section 13 till your section 23, I guess, or 24. Yeah, till 23, because 24 is repealed. So in my next video, I will be completing the remaining sections of the Contempt of Court. So our Contempt of Court Act will be totally completed, right? So if you like my video, subscribe to my channel, like my video. Have a good day. Bye.